The European Regulation on Artificial Intelligence aims to make the European internal market more efficient by standardizing the regulation of artificial intelligence. It also fosters anthropocentric and trustworthy AI, while securing a high level of protection for health, safety, and fundamental rights. The regulation establishes a uniform legal framework for regulating the development, placement on the market, startups, and usage of AI systems within the European Union. An important part of the regulation is finding the right balance between innovation and protection. The AI Act focuses on a risk-based approach, calibrating the legislative actions according to the level of risk posed by different AI solutions. For example, high-risk AI systems require rigorous prerequisites to be approved, while low-risk systems are subject to less stringent regulations. In addition, the regulation establishes normative sandboxes as a means to facilitate innovation, particularly for small businesses and startups. These boxes are designated controlled environments where innovative solutions can be tested and evaluated under the oversight of the relevant authority. The regulation is based on 7 non-binding principles designed to encourage the development of trustworthy and ethically viable technology. The principles, created by a committee of high-level AI experts from the European Commission, are as follows. Firstly, human intervention and supervision. This means that AI systems must be developed and used as tools serving people, respecting human dignity and personal autonomy, and functioning in such a way that they can be adequately controlled and supervised by humans. Secondly, technical resilience and safety. This means that AI systems should be developed and used in such a way to enable robustness in the event of problems and resilience against attempts to alter the use or performance of the AI system, so as not to allow the illegal use by third parties and minimize involuntary damages. Thirdly, private life and data governance. This means that AI systems should be developed and used in accordance with privacy and data protection legislation, processing data to the highest quality and integrity standards. In the fourth place, we find the transparency. This means that AI systems should be developed and used in a way that allows adequate traceability and explainability. This makes people aware of any circumstances in which they are communicated or interacted with an AI system. It also properly informs the people responsible for deploying the AI system of its capabilities and limits, as well as any people whose rights are affected. In the fifth place, diversity, non-discrimination, and equality. This means that AI systems should be developed and used to cover a range of subjects, as well as to promote fair accessibility, gender equality, and cultural diversity. At the same time, any unfair discrimination or prejudice that is forbidden by EU or national law must be avoided. In the sixth place, social and environmental well-being. This means that AI systems should be developed and used in a sustainable and environmentally respectful way that benefits humanity. This involves monitoring and evaluating the long-term impact on individuals, society, and democracy. Finally, the accountability. This refers to the provision of mechanisms that ensure the responsibility and accountability of AI systems and their results. The AI Act is intended to complement the current European legal framework, not to replace pre-existing regulations. The rules established under the regulation should apply to every sector and, in accordance with the new legal framework, should not undermine present union law, particularly with regard to data protection, consumer protection, fundamental rights, employment and worker protection, and product safety. The regulation supplements all of these disciplines. Therefore, all rights and remedies provided by these EU laws remain fully enforceable by consumers as well as by any person who may be negatively impacted by AI systems. For example, a company that wants to develop a virtual assistant should comply with the GDPR with regard to the processing of personal data and with the AI Act with regard to the AI solution specifically. Similarly, an AI system used in the workplace should comply with the labor law and the AI Act requirements. Furthermore, according to European Union law, these obligations imposed on different AI chain operators should apply without prejudice to national law. For instance, the AI Act should not affect the national labor law and child protection framework, provided that these provisions do not specifically relate to AI systems and pursue other legitimate public goals.